My jaw dropped watching the Sarah Boone hearing. We got a preview of how they are going to argue self-defense, and I want to be very clear that this was worse than anything I thought Sarah Boone herself would come up with pro se. So what's going on? Well, today we had the Sarah Boone motions hearing. Big day, as Sarah Boone's battered spouse defense hangs in the balance. I'm going to go through my notes. They're not exact. It's just what I wrote down, what I thought was important through the hearing, because I know a lot of people can't sit down and watch them. I also am going to go through the motions afterwards. I have them behind me. There are 4 of them. Very interesting ones, by the way. The state says that since Sarah Boone's statements to their expert was just last week, they expect that to be her testimony. The purpose of this pretrial ruling they want is if this is Sarah Boone's evidence at trial, and if she'll get a self-defense instruction, will she get reputation evidence of the victim and be able to use it? Will prior instances of violence be allowed involving the victim to be mentioned if this is Sarah Boone's testimony? The state wants to know that if what Sarah Boone is going to say in trial is what was said previously to their expert without any credibility decision about whether she's telling the truth or not, is that statement amount to what is needed for battered spouse syndrome? The state says no. So to put it simply, the state just wants to know what is going on in the scenario that what she told their experts last week is what she says in court. Because if it's what she says, it doesn't match in their belief what is needed for battered spouse. And we can go ahead and deal with this in a pretrial motion. Of course, all of this is out the window if Sarah Boone changes her story again. The state says the victim did no overt actions that day to trigger a self-defense response until Sarah Boone committed 2 forcible felonies and 1 unforcible felony. So they are arguing that there was nothing that could possibly be considered overt as a threat until Sarah Boone had already committed violent acts against him. The state went through Sarah Boone's story of the day. She gave experts. Now, I previously covered this when I covered this motion. They're having a good day, playing games. She talked of wanting him to call his family, which she knew might upset him. The decision to play tag, the hide and seek, George getting into the suitcase, Sarah Boone zipping him into the suitcase, except for 2 fingers can get out. State makes sure to say 103-pound man. And at this point, they're laughing without reason of imminent danger. Only when he says he cannot breathe. Now Sarah Boone told the doctors she got angry and wanted him to feel what she felt in the past. Sarah Boone shakes the suitcase. She hits it. She flips it over. He sticks his fingertips out and she beats them with a bat. Sarah is the initial aggressor. Aggravated assault, aggravated battery, 2 forcible felonies. Stating she only wanted to keep him in there for a few minutes. She thought he could get out and didn't mean for him to face greater bodily harm. She then goes upstairs and she is facing death or great bodily harm once he gets out, which she says she expects when he gets out. The state says there is no self-defense if that is what her testimony is, so the jury shouldn't hear about prior instances of evidence involving battered spouse and reputation until there is evidence that there is self-defense under the state of Florida's laws. The state wants a preliminary ruling that if this is her testimony, no past instances of violence, no reputation of violence, or battered spouse syndrome evidence is given. The case law supports clearly this evidence can only come from here. There is nothing else, so she should have to testify first and should meet the requirements. It shouldn't come in before Sarah Boone's testimony. So basically what they're saying is, unless Sarah Boone changes her story and actually makes it self-defense in some way, all the self-defense evidence should not be shown in trial. And it should not be shown in trial if she is going to change it until after it has been changed by her giving testimony. Remember, you can't unring the bell. Once the jury gets told about, his past or anything like that, you can't make them unhear it even when you strike it. The state said this is fair. It isn't forcing her to testify. Sarah chose the battered spouse syndrome defense. You can't put the toothpaste back in the tube. Rewording what I said. The state understands she can testify differently again at trial. That's a different argument, because the state argues if she changes her testimony against it, she should give a narrative testimony. No attorney allowed to participate putting forth new testimony. So I think I understand how this works, that a narrative testimony would be Sarah Boone going up and basically reading off a script, I believe, and basically telling her story. There wouldn't be a cross-examination or a rebuttal, and like her lawyer couldn't interject at all, from my understanding. So it would basically be solidifying her into a story. Maybe I'm misunderstanding that. Maybe there isn't like a note story there. Maybe she has to like memorize her plan, but that's my understanding. The defense responded. Now, you might be familiar with Mr. Owens, the lawyer that was, the original one to take her case after the circus-style ad. He's not the one that came up for this. He does come up later, and him not being the one that's up here actually comes into play for this. That's why I mentioned it. And if you want to recognize this lawyer, if you watch any appearances, I believe this is her only black lawyer. I didn't catch his name in the court, but that's a way you can identify him. I have to quote the opener from her lawyer because it kind of set the stage. Good morning, Judge. I'm a little confused. Aren't we all? Defense says they understand the state isn't against this being mentioned in voir dire, which is basically the state isn't against the questions surrounding self-defense being asked to the jury during jury selection. So you could ask, like, do you believe that you can kill someone in self-defense and it be someone should be found not guilty, or that type of stuff. Questions about like battered women, stuff like that. Which, yes, the state has made it clear they aren't against that, because Sarah could theoretically change her story again. So you'd ask the jury members that because it's a possibility and it's important. So the defense attorney says his takeaway is no mention of battered spouse or anything like that in the opening statement. The judge says that his takeaway is that from an evidence perspective, evidence about battered spouse can't be raised until there is a factual basis for it. The judge says his understanding of the defense expert's deposition is that the basis of her opinion is on her 4 or 5 interviews with Sarah Boone. He asks the defense if accurate, and the lawyer has to confer with the other counsel. The defense asks him to repeat, so judge changes the question. If they were in court and Dr. Harper was testifying, what is factual basis component in order to get her to testify? So what is the sufficient factual basis of her opinion? The defense says the interaction over the course of time with Sarah Boone, and she has reviewed other evidence in this case and her knowledge of battered spouse syndrome. Some people who suffer from things they don't know they might suffer from, like people with mental health situations, they get evaluated by a doctor with experience of what to look for. Judge goes back to a case cited by the state and asks if they are using statute 776.012 as their basis. Defense says yes, but the problem they are having is that self-defense is an affirmative defense available for anyone. Judge asks, but what is the overt act? In reviewing Dr. Harper's deposition, there were questions by the state about the imminence of fear, and she was unable to answer those questions. So, Dr. Harper, the defense's expert, was asked, what is the act? What is the thing that makes this self-defense, made Sarah Boone fear for her life? And the defense expert couldn't tell the state. The battered spouse expert didn't know what was the proof of battered spouse. There is specific case law that an overt act is needed. The defense says the overt act has to come from testimony. The judge asks again, what is the overt act? The defense says it has to come from Sarah Boone's testimony, and that testimony can only happen at trial, and you have to give the self-defense instruction based on evidence presented at the trial. The judge says he agrees with that, but we aren't talking jury instruction. This is pretrial. The judge is saying you cannot proceed with battered spouse defense based on Dr. Harper's opinion, or before it can be argued, there has to be a basis. The judge is asking, how can we have anyone testify with opinion or reputation or conduct until the overt act is established? The defense says they don't know how they can bring Dr. Harper up for testimony before Sarah Boone to establish the relevancy. Sarah Boone is the only witness and has to present evidence of self-defense, has to present evidence of the overt act. It isn't based on what the doctor says or what she told or what questions were asked at the depositions. Mr. Owens took the deposition. The questions of the deposition are limited. So basically, the lawyer being asked questions about the deposition wasn't the lawyer at the deposition. That's why I said it matters that Owens wasn't the one talking here. This has to be based on what does Sarah Boone testify on the stand, and if any of that presents evidence of the self-defense instruction. The defense lawyer doesn't think this is appropriate to make at a preliminary motion. The defense is basically saying, this will all get handled at trial. We'll handle it at trial. She's got to testify at trial. The judgment can't be made until the testimony of Sarah Boone takes place at trial. The state's rebuttal. And I wanted to quote this. Apparently, the opposing counsel has not read the depositions, or he clearly didn't attend them as he was not there. But the state has the statement Sarah Boone made when asked what happened that day, what happened next, and there was no overt act taken by the decedent that day. What they want to do, and what isn't permitted under case law that was cited, one about getting a threatening text, and then 2 days later you can't go slit someone's throat over a threatening text 2 days later. And the state says not to dehumanize Mr. Torres at all, but he wants to make an analogy. If someone owns a bad dog, and that bad dog bites, and that bad dog has bitten in the past, but on this particular day, that dog is just doing arts and crafts, hanging out drinking some Woodridge Chardonnay, and you put the dog in a suitcase, and then the dog barks when it was in the suitcase because it didn't want to be in the suitcase, and that triggers you because you remember when the dog bit you in the past. You can't. That's not how this works. That's not how self-defense works. With or without battered spouse syndrome, you can't bootstrap and make up a fictitious act of violence on that day based on past violence. That is not what the case law allows. Unless the defense is saying the testimony will be different at trial, they are asking the court to prevent them from saying anything about battered spouse in opening statements because they will know based on the court's ruling what their client has already said to the doctors does not admit self-defense evidence into the case. If this is what the testimony is going to be, self-defense doesn't allow, and battered spouse evidence isn't coming in either. If the defense does make the statement they cannot fulfill in the opening statements, the state can point that out to the jury, and that is allowed under King v. State. Now, let me kind of zone back in here. I know it's a lot. I was reading right from my notes. I kind of got into the groove. What the state, from my understanding, is saying here is the defense can't prove an overt act. There wasn't an overt act. We are using Sarah Boone's own testimony. And if the state is allowed to make statements during the opening statement about possible self-defense, that is opening it up. If the defense is making that statement in opening statements, that is opening the state up to be allowed to point out to the jury it wasn't self-defense. They can point out things, and that is not violating anything against the defense, right? They're basically saying, Judge, we don't want this in the case, but if this is put in the case, we're going to go at it because we have evidence against it being self-defense. And our evidence is Sarah Boone. The tip of the iceberg is second-degree murder. The rest of the iceberg is a self-defense that just isn't there under statements to police or current statements. If this is what the evidence is at trial, the court shouldn't allow any of the battered spouse or reputation evidence in. The defense is back up speaking. It is not the responsibility of the defense to present their case at a pretrial hearing. The judge responds. The problem is that the state's argument and the case law presented by the defense in the filing is about jury selection. The issue is the requirements to establish battered spouse. The state's argument is due to lack of an overt act based on what Dr. Harper has relied on. After meeting with Sarah Boone, that element is lacking. The case law talks about overt acts. The state's argument is that the overt act is lacking. Defense says it is not missing. The overt act is not missing. Okay? But he finds himself in a position where he has to expose what their version of the overt act is. It is an exercise by the state to learn our theory, our view of the evidence. The overt act is in the physical evidence and mentioned in the deposition. The overt act is his hand coming out of the suitcase. Based on history, she doesn't have to wait to see what is going to happen when he comes out of the suitcase. It is followed up by physical evidence of Mr. Torres' hand that matches up with the bat. It's like a gun. You don't have to wait for them to pull the trigger. Let me explain this. So, Sarah Boone is admitting to hitting Jorge Torres in the hand with a bat, smashing his fingers, trying to, get out of the suitcase. We know this. And I was like, why is she admitting this suddenly, right? That is their overt act. The overt act to justify Sarah Boone's self-defense is that Jorge Torres put his fingers out of that suitcase. Jorge Torres putting 2 fingers out of a suitcase when he can't breathe is being compared to like a gun and not having to wait for them to pull the trigger. What do you mean that is your overt act? What do you mean that this is the basis of her defense? I was blown away. I had to pause. I stood up and walked around. I had to play catch up. I paused it because I couldn't grasp it. Imagine you were on a jury. You don't know any of the evidence of this case. Imagine you're talking to someone even. You're not even on a jury. Someone's talking about, let's say they didn't kill their boyfriend, but they got into a fight. It got physical. And maybe they got arrested for it, right? And they're trying to justify it to you. An assault, right? They're charged with assault. Domestic violence. They're trying to justify it to you. And they're like, well, I was the victim. I did it in self-defense. And you say, oh, what did they do first? And they tell you they tried to open the suitcase they were in that they couldn't breathe. It doesn't work. I'm not saying Sarah Boone has a better defense. I had no understanding of how she was ever going to claim self-defense in this personally. But I wouldn't have even tried with that defense because there's nothing there as far as I'm concerned. Maybe I'm wrong. Maybe I'm wrong. I was blown away. I know I'm like kind of stuck here for a moment, but just reading it back, just reading the notes back. What do you mean? How are you saying this? Okay, let's move on. The state's motion got granted in part and denied in part. With regard to exclude battered spouse evidence outright, denied. Battered spouse can be in. Excluding mention of battered spouse until basis is granted. Lots of case law given to explain. The defense can, if they want, mention it in the opening. So the defense can mention it in the opening, and the state already made it clear if it's mentioned in the opening, it's fair game for them to tear apart. On to the next motion. Motion granted with regard to the toilet statements. So, if you didn't watch my previous video, you might be confused. Sarah Boone gave some statements about a neighbor and how they won't let her use their toilet, and how one of the neighbors might be there illegally, and the defense wanted them gone for obvious reasons, and the state has no problem with it. Now, on to the attempt to get rid of the other part of the interview. This one I wrote down in my notes. If this is the one I'm remembering right, the argument, it was including the police making inferences about Sarah, which we'll get into as it goes. The state responded, you can make statements like that in the interview. You can just do it. In court, the state says the case law cited by the defense is exclusively testimony of other witnesses. State seems confused about the defense's argument in general. Things get a little testy, by the way. Like, I don't know how to really describe this without watching. basically the defense, Mr. Owens asks a question, and the state responds and just kind of, moves on. And Mr. Owens keeps going, and eventually the state stands up and they point to someone in the back of the room, and the state says there are no state witnesses, kind of angrily, and just kind of looked at the judge, and then we just kind of move on. I'm assuming that the defense was thinking someone in the back was going to be testifying today or something and was mad about it. I don't know. It was off mic. It was hard to hear. I listened to it like 3 times. That's what I gathered. Defense argument. Defense says state didn't include part of the statute in their response. Not exact. I'm not going to repeat it exactly, but police opinions and statements regarding guilt are generally inadmissible unless they render defendants' responses incomprehensible. If it can't be directed, there needs to be not directed. It's redacted. There needs to be jury instructions. This was a 2-hour interrogation, a day or two after the event. That morning, the detectives discovered the recordings on Sarah Boone's phone. Sarah in the interrogation said they do not remember making those recordings. The police spent 2 hours interrogating Sarah in an attempt to get a confession. The law says they are allowed to use a variety of interrogation techniques, but as a last resort, the detectives made prejudicial statements that are opinion. Not exactly quoting. He said he is dead as a result of your actions. Sarah Boone responded she understands that. You realize you are the one who killed him. She said, I thought about that. Intention or not, George is dead. You act like saying unintentionally absolved you of everything. The defense says those are prejudicial. State says that part wasn't included, as they included the part that would be read to the jury. So basically that the part of the case law that wasn't included, or the law that wasn't included was because that part isn't read to the jury. They only include the part you read to the jury to the judge. He isn't giving an opinion of the law. He's giving, and the interrogator isn't giving an opinion of the law. He's giving an opinion of her intention and what transpired. Defense mentions him not including the portion again. The court grants the defense's motion. So those statements go to objections, of course, for George Torres' death. They are prejudicial. They need to be redacted. So they are getting redacted. So all those statements there where the interrogator is basically like, you did it. That's going to be redacted. Now we have a motion to exclude George Torres' medical records, and we get more information and backgrounds about these, which is rather interesting. The state says it is 550 pages from 2017 and 2018. This is from the defense. The defense sent this to the state. And a third email the defense believed contained attachments, but didn't. So this is just about the 550 they've gotten so far. Excuse me. 480 pages were about George, saying unknown men jumped him and beat him up. They believe the testimony Sarah Boone's going to give is that this was during a family gathering. Sarah Boone said George committed violence against her and he got beat up by his brother. It is irrelevant if he got beaten up by his brother. The extent of damage, and the extent of damage is irrelevant as well. This sounds like classic hearsay. It doesn't like 480 pages for the narrative. If allowed, a handful of pages all it should be needed. They don't need toxicology reports or nursing rounds. It's prejudiced and confusing. So basically, what they're saying is George got beaten up by his brother and needed facial reconstruction surgery. And he got beaten up by his brother because Sarah Boone said something to his brother that got him to beat him up, almost beat him to death. I think that reference is made later. So they don't think that is relevant, like any of it. But if it is relevant, why is toxicology reports and nursing rounds needed to be given to the jury? It's just prejudiced and confusing. It's too much. Owens is up now. Owens complains about 500 pages of communication with Sarah Boone in the jail. The defense says it has to go through them all. So his response to the 550 pages is to complain about 500 pages the defense received. Judge says that isn't relevant to this. So the judge is basically like, stop your bitching, right? Like that's what that is, right? Like this, he wasn't bringing up 500 pages of communication as some sort of like a defense here, right? He was just saying it because he wanted to complain back. And it also, the state does have a response to that, by the way. We'll get to that when we get to it. The defense says they agreed. It needs to be narrowed down, but is early. Defense asked, did the prosecution not have those medical records previously? And I believe the state said no. The defense said the state was aware of the medical records, and the judge says that doesn't mean they had them. and jumped in. The judge says volumes of documents have been exchanged between parties, but this isn't relevant to this argument. So the judge, again, is trying to get the defense back on track. Your complaint about how many pages they are isn't relevant to, are the pages relevant? A lot of relevance said there. The judge explains the defense has to show that these aren't prejudicial, what parts are needed, and to establish the self-defense. The defense says that will become relevant after trial. The judge asks all 40 pages about the window incident. So there was an incident about a window where George, his fist went through a window. Are all 40 pages needed? The defense says it needs to narrow it down. The judge says, narrow down to what? The defense says he'll present it next week. So he will let the state know then. The judge says that's not how this works. The defense says he can't narrow it down today. And the defense, and I re-listened to this part multiple times, George Toros. Now, unless I've been saying it wrong and everyone I've ever listened to said it wrong, it's George Torres, and he says Toros. I don't know, maybe don't make that mistake, especially in front of the jury when they're there in the future. Was over 1.31 in one of those records for his BAC. The judge asked if this is about the 2018, but the defense says they would have to look. Defense says when he is drunk, when George is drunk, he gets angry, and they're going to establish it. The best they can do is narrow it by Friday. The judge then asked about the 480 pages for the facial reconstruction. What does his surgery matter to prove the incident took place? Defense says it will be after Sarah Boone testifies that the termination will be done. The judge says that isn't how it works. The judge can understand BAC and why he's there, but how are nurse rounds relevant? The defense says maybe some aren't relevant. State says, and this is the explanation for the pages, the state gave us 500 pages. The state says the two-party discovery response are not equal. The state has to provide everything, and the defense has to only show what they are using at trial. The defendant got these records in 2022 or 2021 and just disclosed the other night. For weeks, the defense was saying they didn't have them, but they were sitting in Sarah Boone's box for years. There are rulings from this court for schedule of what is being introduced. The state has narrowed down the phone data to about 160 pages of the phone. Phone data is very important. They mentioned it now. We'll get to it later. It's the next motion. I believe it's the next motion. A few dozen photos and videos. They aren't asking for much. What does BAC matter at a family gathering when Sarah Boone says something that gets George Torres' brother to almost beat him to death? What does it matter? What does it matter how drunk George was when Sarah Boone got someone else to beat him up? Okay, ruling. State's motion granted in part. Why Torres was seeking treatment, admissible. Information regarding blood alcohol content, potential relevance for now. Motion granted in Lime when it comes to other medical records, such as medical rounds. So, why he was hospitalized, sure, you can say that. Blood alcohol content, probably case by case, make the argument. The rest of it, throw it out. Next to the objections and evidence, the judge is confused about what exactly the state is talking about, so the phone is after this. It's just a number listed, and the state says they had to keep scrapping responses because evidence numbers from the defense kept changing as items were added. The judge is asking, where is the defense's amended list that they're even talking about? And the state says the defense might have not even filed it with the court. The state directs questions about possibly not being filed to the defense. They need to get these documents for the judge, so they move on to some housekeeping, like juror testing positive for COVID. The judge says they will host jury selection in the current courtroom. It says a larger one. This is taking place while they're trying to get these documents for the judge. Then the state says, well, wouldn't it be smart to do it in the larger room since one juror had COVID? Because the judge was like, hey, we're going to do it in this small, cramped room. We brought in extra chairs. And the state's like, well, I'm pretty sure it was the state. It was like, well, if people have COVID, maybe spacing out's better. Mike got muted. Lawyers approached. Sarah Boone looks like she's feverishly writing something. 15-minute recess. Once back, judge asks him to approach. Muted mic. Sarah Boone is seen smiling, and then she's like shifting through documents. I hope these are hers, like her own copies, because I would go crazy if I was like speaking to someone and came back and everything on my desk was just shifted around. So we're back, and this is the black defense lawyer from earlier, not Owens, up speaking. This is the defense motion I'll be going over after the court stuff. So I am hearing this and writing notes about this before I review that motion. The defense is objecting to all photo evidence from the phone. As foundational, he says it doesn't have dates, so he is at a loss to that. He doesn't know until who's putting it in, why, when is it relevant. So he's basically saying, I'm looking at this evidence. I don't see dates. I don't understand. When does this photo tie to what? I don't know when it was taken. The clerk is provided a very carved out relevant photo data list marked as D. It is specific to 59 pages labeled as case in chief, rebuttal as the other on 08. So there's two separate sections. We have case in chief and we have rebuttal. Attachments to case in chief are 80 photos and video. Attachments to rebuttal are 147 photos and video. There is metadata with all of these files. Now, I'm not an expert in phone data, but I do have a degree involving computers, so I have a little bit of knowledge. When you take a photo, it includes a ton of data in the actual photo itself, in the file. It'll have like the camera you used, it'll have sometimes the location, it'll have the date. It's all there. And it's weird to me that if this data was provided, that the defense, the lawyers didn't know what they were looking at when they have that data. You know what I'm saying? Like, I feel like any case involving phone data would include the dates. I find that weird. Like, maybe that's something most people don't know, but I would think defense lawyers would know. The court's given an example of basically what's going on here, that the file names provide context in the PDF. One of the examples they use is like the page, photo, and metadata info, and like basically they're giving giving information where if you go to this one page on the document, you can tie it to this photo and this metadata, proving it was at this time and tied to this occurrence, right? The state gets an example given, basically explaining how this works. Some data might be missing from like deleted documents, so I'm assuming like deleted photos or videos. Those can be recovered. You might lose some of that excess data. They have what they can get. And for example, the example they use giving the page and the metadata and the video data is actually George in the suitcase. And the context for that is in the metadata and the timeline provided by the state. An example of other stuff in it would be a conversation on Christmas 2019, Mo talking to Sarah about hide and seek. And then the state gives another example. On the 13th of January 2022, Sarah presumably says, "And bless you and all of you too, I'll get rid of him." Those are the conversations in the case in chief, and I believe rebuttal would be the rest. So the rebuttal file, conversation with George or about him, conversation with his family, of which she claims she's afraid of. All photos of her child and the friends aren't in it. Photos are there for context, like when she's talking about an argument, you might expect photos of injuries, but she's taking photos of art. So this example they're giving is, I'm assuming this is a real example. At some point, Sarah Boone is texting about an argument she got. Maybe it got into it and it was violent, right? And at the same time, she's texting people about this. She's not taking photos of her injuries. She's taking photo of the arts they did. You know, like that's like if and this is in the rebuttal. So this would only come up if they needed to like respond to Sarah Boone's statements. The state provides evidence of authenticity, concedes George also used Sarah's phone, which is used in some of her statements about porn and texting other women. Context shows who was using the phone. Specifically, only entering context and statements about hide and seek and getting rid of him in the context of the day. Context of her with family. There is no testimony hearsay because none of the statements were made with the expectation they were for testimony. The conversations other people were having, back to the statement, is just for context of what she is saying. She said things like, "I'm going to bond George out. I'm going to go to the public defender's office," or yelling at his family. Of course, deleted data might have some missing information. I hope I explained that well. I think I rewrote those notes like 2 or 3 times. Basically, the state's just saying the data we have, it makes sense in context. We have the case in chief. It is a line-by-line outline of what we want to provide in the court. The rebuttal is just a list of things that we might need to use to basically disprove Sarah. And I'm sorry, my throat is getting a little dry at this point. Defense response. The defense says this calls for a lot of speculation because he doesn't know how things like art on the wall is relevant. If we're talking about art, I'm assuming she's like taking photos of art they did together on the wall while simultaneously texting people about how George was being violent. But if that appears to be part of the rebuttal, so it wouldn't even matter because it won't even be brought up in court unless it's used in the rebuttal. The judge asks, what about the lack of specificity? I always mess up this word. What about the fact that it's a boilerplate objection to all the videos and all photos? The judge, the judge is asking, if you're saying, if you are saying that you aren't objecting to all of it, just some of it, why is your objection written as all? And the defense says it isn't an objection to all photos and videos. So the judge quotes the defense. It is an objection to all cell phone evidence that states intends to produce. So all cell phone evidence. The defense says he can't say what the independent objection would be. The judge says that is all about the potential rebuttal evidence. What about the evidence they plan to put forward for the case? So basically, the judge is saying it seems like his objection is to rebuttal evidence. But what about the evidence they're using to put forward? The actual evidence they're putting forward, right? Like the 40 pages versus the other, or not 40, but the smaller one, the case in chief section. Defense asks, how do I know if they have that proper basis? He doesn't know what they're using it for. Defense says they aren't objecting to the video of him in the suitcase because it has basis they can see. The judge says it sounds like they are objecting to the suitcase video and repeats, objection to all photos and videos. The defense says correct. The defense is saying we are not objecting to the videos of him in the suitcase. The judge says, well, it sure sounds like you are. You're objecting to all videos and evidence, and videos and photos. And the defense says, yeah, correct. The defense says we aren't objecting to it, but it doesn't outline that in the document. It does list some names of files. So it's weird. Like, I don't think this defense lawyer understands what the judge is saying. Because how are you not objecting when you are objecting, right? I feel like they're talking past each other at this point. It's actually really aggravating, and that might be why my notes are a little confusing to you. It's just, I feel like we have two conversations going on. The judge is basically like, okay, what are you objecting to? Because it says you're objecting to everything. And then the defense is saying we aren't objecting to everything. Here's an example of what we aren't objecting to. And then the judge is saying, well, you did object to it by this wording. And then the defense says correct. And they can't be on the same page. The judge says it is a low bar for admissibility. The defense says he doesn't want it later, to be said later. He didn't object to it now, so he can't object to it later. The defense lawyer says he knows this is a different jurisdiction, but he has never had to do this in a case. So the defense is basically saying, look, I'm putting the objection forward because if I don't want, in the future, me wanting to object and then not being allowed to. Now, this is about where Sarah Boone damaged herself. The judge says that this is because Sarah Boone was representing herself pro se, and deadlines would prevent issues at trial. None of those dates were waived. The judge tells him he can object at trial. The defense said his worry was not being able to object. The state says the issue today is about redactions or blackouts of specifics that shouldn't be allowed. That is what the state was hoping for. So the defense was wanting to just cut everything out. The state was like, we wanted to go into specific, right? We wanted to be like, what are we blacking out? Judge overrules the defense's objection, so they don't get what they want. Now, the defense says there are photos of children being put into evidence. Now, the state says they weren't. The state says they didn't think there was. The camera shows the state scrolling through checking, and he says he doesn't see anything in the folders he gave the court. And there's a moment where you see the defense and the state both scrolling on like a laptop. Defense finds it. It's a reflection of children in either a snow globe or aquarium that the state didn't notice. No objections. And then we get an amazing line. The state says, I didn't recognize it as children. I recognized it as, pauses, looks down at the image, comes back up, a crab. Somehow, the state saw a reflection of a child and thought it was a crab. I don't have an answer to that. The judge hasn't seen it, so he's at a loss. So I'm not alone, right? I'm like, I want to see that photo more than any other photo in the case at this very moment. But it will be removed, so we'll never see it. We'll never get to know about the child crab, right? Defense backup speaking says he won't know the purpose now of the images, and the judge basically just says the ruling will be tomorrow. They got to do the jury, so they're going to move to that larger room. So yeah, that was the hearing. So we don't actually have a decision yet on the phone evidence. I can't imagine the judge not siding with the state. So basically, the state seems to have put in so much effort. So much effort. I don't know if I really conveyed it. Like, they have two separate documents. The one is a full timeline of exactly how, when, and why, what they're putting in. The second one is just things that are there put into evidence because they needed to be put into evidence because they might be using it as a rebuttal. And the relevance of that will be based on, if it's relevant, is if Sarah Boone tries to lie about those dates and times, right? Like, it feels like a really weird Hail Mary from the defense. And the defense is saying, like, yeah, we're not against the suitcase video. But their motion is, I'm going to have to cough, and then we're going to go into these motions. So, 1 second. Excuse me. I thought I had more to drink, but I ran out, and it's catching up to me now. So, state's response to defendant's Fifth Amendment reciprocating discovery. I have not looked at these, by the way. I have not looked at these. Comes now the state of Florida, by and through the undersigned assistant state attorney, and states alleged as follows. The state objects to the defendant's use of state exhibits, in that many exhibits the state can introduce, but the defendant cannot. For example, the state may introduce hearsay statements of its party opponent, the defendant, whereas she would need another hearsay exception to introduce her own statements. The state objects to item 1. The defendant has not disclosed his item to the state. Now, we don't have the numbers, right? This is what the judge was looking at and was confused. Like, I don't have this evidence, right? I don't have this list. The state does not object to item 2 if it is the 81 pages of records sent to the state on September 27, 2024. No custodian records need to be called by the defendant. This lack of objection, as with all objections, is contingent on the court's ruling regarding battered spouse evidence. All prior acts of violence being allowed into evidence over state's objection due to defendants failing to set forth a legally recognized claim of self-defense. State objects to item 3. A separate motion in limine was filed regarding this item. State objects to motion 4. The defendant has not disclosed this item to the state. The state objects to item 5. The separate motion in limine was filed regarding this item. The state objects to item 6. The defendant has not disclosed this item to the state. The state does not object to item 7. Is the 57. So this is again with the battered spouse stuff. State objects to item 8. Police reports are inadmissible hearsay in Florida. It is unclear whether the defendant believes she can use these reports in her case in chief or for potential impeachment. The latter may provide some limited admissibility. Reliance on inadmissible evidence by experts is permissible, but it does not make the impermissible evidence admissible. The state agrees to the introduction of the body-worn camera footage the defendant wants to use in the bargain and consideration for the state being allowed to introduce particular body-worn camera footage the state wishes to introduce. The state has previously notified the defendant which files this is. The state objects to item 9. Police reports are inadmissible hearsay in Florida. And again, this seems to be a repeat of the above about body cam. The state objects to item 9. Police reports are inadmissible hearsay in Florida. Again, it's another repeat. The state does not object to items 12 and bargain consideration. Now objected to in a photograph of George Torres from this incident. So this is another repeat. So a lot of this is basically, as you can see here, 12 through 15 are all, we don't object if the defendant doesn't object to photos of George. Item 16 is a repeat of item 11, so they aren't even like curating their list. The state objects to item 17. While the state may introduce statements of the defendant's party opponent, the state is struggling to see any hearsay exceptions that would allow the defendant to introduce any jail phone calls. So Sarah wanted to put in jail phone calls, and they said no. The state objects to item 18. If the defendant does testify she used justifiable deadly force against George Torres on the evening she killed him, she is permitted to testify to prior acts of violence committed by George that she is aware of. This, however, does not allow a rap sheet be admitted to evidence. Whether anyone was arrested for prior violence is not relevant, nor is the disposition of any of those charges. Police reports are hearsay. This is apparently a letter from Math, which the state recognizes as a contact in the defendant's phone. It would be hearsay. It's also dated March 20th, 2020, so there's additional questions revolving its relevance. That would be after, right? That would be after. So, like, someone she knows wrote a letter after and she wants to use it? Okay. The state objects to item 21. These court records will be filed with inadmissible hearsay, questionably relevant materials, police reports are inadmissible. The defendant testifies at trial to justifiable use of deadly force. The defendant will be permitted to introduce evidence. There are admissible ways to put past incidents of decedent's violence into evidence. Court records and police records are not admissible evidence. Simply because an expert eyewitness may rely upon inadmissible evidence in forming an opinion does not make the inadmissible evidence admissible. A lot of repeats, which is expected, right? Like, there's only so many ways you can object, and a lot of them are going to have the same objection. The state objects to item 2022. These court records are irrelevant and filled with hearsay. The state does not object to paragraph 5 of the parenting plan entered on April 3rd, 2028, which states the wife shall not consume alcoholic beverages when the child is in her care. In the event that this provision is violated, the time sharing shall be supervised only at the father's discretion, unless until the mother completes a treatment program. How is that good for Sarah? So I have to assume that item 22 is going to be like the parenting plan. I don't know how that matters, but the fact there has to be a provision about avoiding alcohol, I can't view that as a positive to be brought up in the case for Sarah. The state objects to item 23. Policies and procedures of OCSO regarding Miranda is not even a legal issue, as previously decided by the court, much less a factual issue for the jury to consider. So it's basically a repeat of the previous issue that the court's already decided. Now they want the jury to decide it. From my understanding. Remember, we don't have this list, and neither did the judge. That's fascinating. The state objects to item 24. The policies and procedures of OCSO regarding in-house interrogations on a legal issue previously decided by this court, much less a factual issue for the jury. Same thing as before. The state has not been disclosed these records. They likely contain hearsay evidence of questionable relevance. So the state objects without even seeing it because of assuming what the description is. Regarding item 26, the state has in its possession 911 calls from 6/15/19, 6/18/19, 9/4/19. Despite containing self-serving hearsay with no valid exception, the state does not object to calls on those dates. If the defendant has required other 911 calls through due diligence, which she can, the defendant does not disclose them to the state. So I'm assuming that if the state's saying, hey, it's hearsay, but we're going to allow it, they have a plan, right? It's not going to go good for Sarah if it's used. The state objects to item 27 unless the defendant establishes relevance. It does not appear to be relevant other than showing that the defendant has no injuries. The state does not object to item 28. It is included in the narrowed down portion of her phone extraction. State objects to 29 and unless the defendant testifies to make it relevant. Per her medical records, this appears to be cellulitis, not an injury. Are you kidding me? Are you kidding me? Did Sarah Boone's defense try to use her cellulitis? The state does not object to item 30. It is included in the narrowed down portion under phone extraction. State does not object to 31. This is included as thumb 450 in the narrowed down portion of her phone extraction. State objects to item 32, an irrelevant photo of the defendant and apparently her child. What do you mean? We just had to go through Crab Child, right? Because the defense didn't want the child shown, and they're trying to show the child. I'm blown away. Another photo of the defendant, deceased, and apparently the child. State does not object to 34. State does not object to 35, although it's duplicative. State does not object to 36 if it's a predicate for a photo can be laid by the defendant. Does not object to 37 if a predicate can be for the photo can be laid. State does not object to 38. It's included in the narrowed down portion of her phone extraction. State does not object to 39. Is included in the phone extraction. 40 again was in the phone extraction. The defendant should be required to testify that this was from abuse, unlike what she told Advent Health. The state does not object to item 41, although it's duplicative of two previous images. The state does not object to 42, although it's duplicative of three previous images. The state does not object to 43, as included in the narrowed down portion of her phone extraction. The defendant should be required to testify that it is from abuse, unlike what she told Advent Health. The state does not object to item 44, as included in the narrowed down portion of phone extraction. The state does not object to 45, although it is duplicative. The state does not object to 46. Provided the defendant testifies as to how, when, and where it happened, that it was an injury inflicted by the decedent, and is a fair and accurate depiction of her at the time. The state does not object to 47. Again, it's an injury photo, as long as she proves it. States item 48 does not have any relevance based on discovery. Does not object to 49. Again, it's an injury photo. Does not object to 50. It's included in the state's phone extraction. Does not object to, which they're trying to also get rid of the whole phone extraction, by the way, but they're also using it here, right? The state does not object to 51, provided the defendant testifies how and when, where it happened. It was an injury inflicted by the decedent, that it was a fair and accurate depiction of her at the time. It feels like it feels like multiple lawyers are working this case. They are, but it doesn't feel like they're working the same case. Like they all got their own plan. The state does not object to item 52. It is included. That's the same for all of these, down to 59. 59, the state objects to catch all provisions of paragraph 5960. We concluded day 2 of the jury selection. The defendant has 58 months to prepare for this trial. Any discovery provided to the state at this point will require a Richardson hearing. Okay. Defendant has listed several witnesses in the past prior to any testimony at trial from the following people. The state requests a deposition of these witnesses, and defendant pay additional costs for expedited transcripts of those depositions. We have the initials. Again, the state's explanation of objections in this response is contingent on any of the past emotional, physical violence the defendant and decedent inflicted upon one another being admissible in evidence. The state's position is because there will be no evidence of an overt act by the decedent that day, no net threat of great bodily harm or death of the decedent. Defendant faced prior to committing the forcible felonies of aggravated assault and aggravated battery and the non-forcible felony of false imprisonment against the decedent, that no justifiable use of force instruction should be given, nor should any past instance of violence or battered spouse syndrome evidence be admitted. We went through that. They're going to allow it. And I think that's it. Yeah, so that's it for the first one. The other ones aren't as long, so let's go. Come on. Again, I haven't gone through them. Defendant's response to the state's motion in Lime to exclude battered spouse syndrome evidence or mention of battered spouse syndrome evidence until defendant testifies. So we have an introduction. On September 20th, 2024, the court found defendant's notice and admitted notice of intent to rely on battered spouse defense compiled by Florida R. Criminal P3.201B. Accordingly, the state's motion to strike defendant's notice was denied. To date, the state filed a motion in limine to exclude battered spouse syndrome evidence or any mention thereto of until the defendant testifies something that is a justifiable use of deadly force. However, the state contention is without merit. In fact, is no more than a final attempt by the state to strike defendant's intent to rely on battered spouse and or prevent the mention of such in voir dire and opening. So this is the voir dire mention, which no, the state was never against it being mentioned to the jury. The state was against it being mentioned without evidence, without an overt act being claimed. And this is a bunch of case law about voir dire and stuff like that. I'm not going to read all that. If you want to, it's there. I feel like we've gone through basically what all that stuff amounts to through court. I feel like a lot of times, some of what the judge is saying, it feels like they're trying to teach the defense how to be a lawyer at certain points, but I think it's partly because they know there's an audience and they want to explain it to the public, because if the public doesn't agree, there's gonna, like, things being handled well, it causes, publicity issues. Let me make sure these are, so this is the defendant's amended response to the state's motion in lime. So this is amended to this. So what's different? I'm sorry, I'm quiet. I don't see what's different. Maybe it's saying in the case law. Actually, I think I did read ahead a little bit here. I think it might be in the case law, so I'm not going to read it. Now here is the big one, right? This is the one the judge hasn't ruled on yet. Defendant's objection to state's digital exhibits. Comes now the defendant by and through the undersigned counsel and objects to the following state exhibits. So this is what the judge hasn't decided on. Defense objects to all cell phone evidence the state intends to introduce at trial due to relevancy, foundation, unknown origin date, and that is repetitive in nature. Defense objects to all cell phone video evidence the state intends to introduce at trial due to relevancy, foundation, unknown origin, hearsay, and Crawford issues. So we get to look at this after listening to the case, right? It has relevancy, they explain that. It has foundation, they explain that. The origin dates are all known due to metadata, which apparently the defense didn't know existed. And the Crawford issues, I'm trying to remember what Crawford is. I'm thinking it involved, because it was mentioned in court by name and I didn't put it in my notes. I think it involved like the chain of custody, maybe? Because I remember the state going through whose hands it went through, right? I think it's that. I might be wrong. Let me know in the comments how wrong I am. Yeah, and it's a list of images. Okay, it's just I'm not going to read out the names. It's just a bunch of file names. Wow, what a day! I don't know what to say. I don't know what to say, everyone. I'm blown away still. With quite a bit. Crab Children was a nice little light-hearted moment. Wow. He put his fingers outside of the suitcase, and that is why that was the overt act. I can't get over it, right? I just about put my fingers up and like made like a hole with one hand and put two fingers through it to like simulate it. Like how is that like an overt act of danger? I don't want that GIF to exist, so I'm not going to do that. Jeez. Like, you're talking about a 103-pound guy. I think Sarah Boone weighs more. So, I mean, she probably does now. She's probably, I'm gonna be honest, she's probably put on some weight in the jail. Like, it's more sedentary. Sounds like she likes her snacks. Um, you got some of the weight advantage, which doesn't always mean a strength advantage, but you cannot dismiss a lot of people. A lot of people like to dismiss the fact that men can be abused by women. And in any case where a man and woman both hit each other, it's always the man in the wrong. And that's not always the case. You know what I mean? Like, I'm not saying he wasn't abusive, but that doesn't make him the aggressor that day. Who's the aggressor can vary by day, and it doesn't excuse it. If Sarah had put him in the suitcase, beat his fingers with that bat, went upstairs, George gets out, takes that bat, goes upstairs, and bashes her head in. People wouldn't argue, oh, well, her breaking your fingers while you're in there, that is an overt act making what you did self-defense, right? And I can't get over that the overt act for Sarah, according to her lawyer, is the mere act of poking fingers out of a hole. What world does that work? I'm trying to figure out, like, what do you have to tell the jury? Like, is it like the story she's painting is very clear to me, right? The wording she uses, we don't have the testimony, but we have the state talking about it, right? The way she words it is like, it almost sounds like Sarah's wording it as if George is a powder keg waiting to go off, and she's spending her day trying to not set him off, right? But then, by her own admission, she tried to set him off a little bit by talking about calling his family, knowing it would do it. Right? And then, while she's trying to paint him as the aggressor of the day, and she's just trying to placate him, his big flaw of the day is he poked his fingers through a suitcase. And Sarah's like, "Oh, I'm scared of his family." Well, I mean, state might bring up that medical record, Well, why are you afraid of his family? Well, his facial reconstruction can go both ways, right? Like, that is a beating due to Sarah. Like, imagine it was more, right? Like, imagine it was more. Like there was more of an overt act. In my mind, you then have a situation where you could make the argument that Sarah is possibly the main aggressor, and he is the he does act out, but is it in defense, or is he the battered spouse, right? There's just so much with this case that the more I hear, the more I sit there and I just wonder, like, what is this, right? What do you mean? It's something that constantly goes through my head, and I think I repeat that more than I should. But I get your words, but what does it matter in this moment? What do you mean he poked his fingers through a hole, 2 fingers through a hole, and that justifies self-defense killing? The way this plays out for me in my head is that Sarah Boone planned this, right? Sarah Boone talked about hide and seek. We don't have the full story, but they have in the case the prosecution is making, they mention her mentioning hide and seek the month prior. Something in her story now. They mention her talking about getting rid of him. And it makes me question that day more when you start hearing Sarah try to paint him as this aggressor, while also simultaneously, by her own admission, doing something to try to provoke him at one point. Is that just because she's an ass when she's drunk? Or was this all premeditated? Like, I'm sorry. Like, you're telling me that she's having discussions about this so-called hide and seek where she knows where he's at? And she's talking about getting rid of him? And then she tries to provoke him? And he doesn't bite? And then she gets him into a suitcase and beats him with a bat? And goes to bed? And her defense is him trying to get out of the suitcase was after she's committed assault. Well, at that point, it's just forceful imprisonment, right? Then it was okay for self-defense, and that's when she beat him with the bat, right? Every time I learn more about this case, personally, I have a worse view of Sarah Boone. But that doesn't matter. It doesn't matter, right? You and me, we don't matter. Most of what we know about this case will never make it in front of a jury. And it matters about the story that they can tell in the courtroom. But that story, according to today, is Sarah Boone feared for her life after seeing 2 fingers of a man trying to get out of a suitcase, so she beat him with a baseball bat and left him for dead. Let me know in the comments. What do you think about that defense? If you made it this far, let me know. What do you think about that defense? How do you feel about it? I can't grasp it. I'll be in awe the rest of the day. Probably. I might not even. I don't know if I don't know if I'll have the mind to do any videos on any other topic because I'm just sitting here wondering, how do you word that in any way to justify murder? I can't think of a scenario to justify even hitting him with the bat, let alone killing him. Well, let me know in the comments. If you like the content, let me know. Subscribe. I think I'm gonna sit there and just kind of moderate the chat and actually. People complained a little bit sometimes about my premieres not having like live chat, and I get that. The comments are open at the bottom the whole time. I don't know if I'll be active in the chat, but I'll probably sip on a